A debt collector texted me and I sued him for it. They texted me without the legal warning, and under federal law, that's worth up to $1,000. And I want to show you exactly what they did wrong, what law they violated, and what I put in my complaint to hold them accountable. All right, so we're here. So this is the text messages that the debt collector sent me to my phone, and this is where they violated the law, the Federal Debt Collection Practice Act, 15 USC 1692 E11. There is a specific detail that in any type of initial communication or communication with a consumer, a debt collector must adhere to. They must state that they are a debt collector and this is an attempt to collect a debt, and any information obtained will be used for that purpose, right? So as you can see here, the debt collector, this is the debt collector's initial communication with me, okay? They failed to do so. They failed to state that they are a debt collector, that they are here to collect the debt, and they've done it multiple times. This isn't the first one. Every single time they communicated, they failed to do 15 USC 1692 E11. Every single time. Now, it doesn't matter if they have these clickable links. These clickable links does not count as, oh, well, we let you know we're a debt collector. You just have to click the link. No, that's not how it works. You have to actually have it written down in the actual message itself. Okay. So this is where they violated, and this is where I ended up suing them. What I ended up suing them for was the 15 USC section 1692 E11. So no Mini-Miranda means a violation. Okay, that is a violation of the FDCPA. So the debt collector texted this a total of 7 times throughout I want to say 3 or 4 month time period. The first initial text message happened in January, and then all the way through April. Yeah, we actually have some from April. I didn't put them in here. All right, and you see they're texting from multiple numbers, so it's not just one particular number. They texted from several different numbers with the same text message. Okay. Now, that's a pattern of behavior, and you want to show pattern of behavior, especially when you're about to file your lawsuit. You want to gather all of your evidence. So make sure you take, I made sure I took the screenshots to preserve the fact that this is there, just in case, phone gets lost, damaged, whatever the case may be. I screenshotted the information, make sure the date and the time was present, so that way they can see that it's from this date and this time. Text message doesn't show the year, but when you're doing an FDCPA violation or FDCPA lawsuit, it's 1 year from the date that the violation occurred, okay? So you have to pretty much move fast because you don't want time to elapse. So I ended up, March was the last text message that I received. I collected all of my evidence, and I ended up going to file the lawsuit, but drafting my lawsuit, okay? Now, I just want to show you here. Exactly where it says. So this is under 1692E, false or misleading representation, okay? E11, the failure to disclose in the initial written communication with the consumer, and in addition, if the initial communication with the consumer is oral, in that initial oral communication that the debt collector is attempting to collect a debt, and that any information obtained will be used for that purpose, and the failure to disclose any subsequent communication that the communication is from a debt collector, except that this paragraph shall not apply to formal pleadings made in connection with legal action. So this is saying the initial communication, and if you need to understand what communication by definition is, the term communication means the conveying of information regarding a debt directly or indirectly to any person through any medium. Now, if you know medium, it means when it comes to communication, it can be text message, it can be email, it can be through telephone, it can be through letter. That is medium, okay? Written, verbal, those are mediums, okay? Now, this is very important to also understand because people tend to be like, well, oh man, they did let me know in the initial communication that this is an attempt to collect the debt from a debt collector because it was on the letter. Fine, perfect, great. However, if they fail to disclose in subsequent communications that it communications from a debt collector. So even if they did the initial communication inside of this text message, that they were in fact a debt collector, the following communications subsequent, they would have needed to say that they were a debt collector. And as you can see, they failed to do so every single time. And once again, these hyperlinks to whatever it's directing you to is not where they can say, oh, well, it is provided here. No, it has to be visible to you at that time. Okay, so you may never click on this hyperlink. Okay, and even if you do, it doesn't really matter if you do. I clicked on it, it didn't matter. All right, so that is where we're pulling this violation from 1692 E11. Now I want to walk you through. Now we know the violation. We know what we're looking for as far as what type of communication they failed to adhere to the 1692 E11. We want to go in and actually start drafting the complaint. Okay, so you have your evidence. You're going to build your case. You're going to draft your complaint now. There are elements to drafting a complaint, and it's very important that you understand exactly what you need to put into the anatomy of your complaint. All right. Jurisdiction and parties. First, you have to explain where you're filing and who's involved. That means stating the name and address of the debt collector you're suing and identifying yourself as the plaintiff. And yeah, you can file in small claims court, but I prefer doing this in federal. But everybody's situation is different because in small claims court, the filing fees are astronomically lower than federal court. But in federal court, because it's a federal statute, the FDCPA, I prefer to do in federal court because it's called a federal question. Okay. But yes, jurisdiction and parties are the first part of the complaint that you need to make sure that you have the information for. All right. So when they say address, you need to get the address of the debt collector. Now, if you don't know where to actually get the address from, I like to use a website called Open Corporates, and you can actually type in the company's name and it will actually provide you with a list of the companies with that particular name. You search for the correct company's name and then it'll give you a list of the actual debt collector's address and or their registered agent's address. Okay. It's best to use the registered agent's address, especially if they have, the debt collector company has a actual filed Secretary of State filing in your state. Okay, so it's best to do that. Next is the FDCPA background section. The reason why you want to do this particular background section in the law itself is because you want to explain to the courts why you are bringing this case to them. Okay, so you want to give them as much information so they can actually understand the reason behind the lawsuit. All right, this is very important to put into your lawsuit, because if you don't, having to explain the FDCPA to a judge is going to be challenging if you don't know why the FDCPA was enacted in the first place. Okay. Next, you're going to put in your facts, or sometimes they call them allegations. I call them facts. Statement of facts. This is basically when the debt collector, in this case, texted you, what was their first time contacting you, what the message said or what it didn't say. And if it happened multiple times, you're going to basically allege every single time that it happened. Because remember, you're trying to show a pattern of behavior, all right? This is not a one-time instance. This is a pattern of behavior for this particular debt collection company. So if you can tell the story of the behavior issues that they basically, what you're alleging to, they're blatantly disregarding the Fair Debt Collection Practice Act and are violating my consumer rights. It can, I don't want to say it kind of can give you more merit. For me personally, I felt like it gave my case a lot of merit, even though I knew what the debt collector was going to say or respond to, how they were going to respond to my actual filing. Next is cause of action. This may actually be, some people may see it as in complaints, they may see it as the violation, whatever, cause of action, whatever. This is the legal claim that you're alleging that they violated. Violation of 1692 E11, right? So you're going to break this down, and then you're also going to break down what the Mini-Miranda warning is supposed to provide you as a consumer, okay? Then you're going to do your statutory damages or actual damages. If you're going through the FDCPA or the FCRA, there is a statutory damage. Like I said, for FDCPA, it's up to $1,000. So you can obtain statutory damages. There is a specific section that is allowing you statutory damages under 15 USC 1692K A2A. All right, that's where you're getting your statutory damages from. And then if you have actual damages, if this actually caused you any type of harm, you can state that as well in the damages section. And then you have your prayer for relief. Your prayer for relief is finally wrapping up in short, which is just legal speaking for telling the court what you want. It usually sounds like, plaintiff respectfully requests statutory damages, court costs, and any other relief the court deems just and proper. And that is how your complaint is structured. All right. Now let's go through mine. I'm going to show you my complaint. All right, so this is the draft of the complaint. Now, I've already filed this. This is not the final complaint, but this has already been filed. All right, so it's heavily redacted just because it is. All right. When you're going through the federal court, you want to do one of two things. You want to make sure that you file your complaint on the proper document, which is called pleading paper, or the U.S. District Court, they actually have a form where you can file your complaint and type it out as well. I prefer typing it on pleading paper in the pleading paper format. All right. So we have the first part, which is basically letting them know the reason why we're bringing this particular lawsuit. I'm bringing this particular lawsuit to the courts. We have the jurisdiction. Remember, I said that is part of the actual anatomy of the complaint. We have the parties involved, and I provide the business where they're located. They also have a registered agent, so we want to make sure we give the registered agent's address because that's who we're going to get served. That's who I served, was the registered agent. And then letting them know that per the Fair Debt Collection Practice Act, as well as the Fair Credit Reporting Act, debt is defined as this. All right. Provided the background. Remember, giving the background allows you to tell the court, tell the judge why you're bringing this case and why the actual allegations are bringing to this court. Okay, why I'm bringing this lawsuit here. And then I did my facts. I listed every single time that they actually texted me, the date, and what the actual text message said. And then my exhibits were screenshots, which I did provide with filing the lawsuit. All right. So then I also have my cause of action. I took the entire FDCPA section 15 U.S.C. 1692 E11, the entire thing. I put it in there because I just don't want no miscommunication. Why are you bringing this lawsuit here? This is the reason why. This is what the FDCPA says. All right. And then I also brought in my state, because my state has their own Debt Collection Practice Act that should be adhered to, and I brought that in as well as a cause of action in the complaint. And then my prayer for relief. And then I sent that off. Fact that they violated. So you don't need to be an attorney. I'm not an attorney, and I was able to get this lawsuit drafted, build my case, build my evidence, gather my evidence, file the lawsuit in federal court, and then I was able to actually obtain whatever my demands were for settlement from the actual company. All right. They ignored my rights. I don't want to say they violated. Well, they did. They ignored my rights. I didn't ignore the law. I used the law. And you can't too. All right. So I hope this information was helpful for you to kind of start your own journey, if that is something that you're looking to do. If you want my FDCPA template, you can definitely click the link below. Yeah, I hope that information was useful.